Hello, you're watching Addleshaw Goddard's Employment Channel. In today's programme, we review the key changes to employment law that came into force on the 25th of June, including changes to whistleblowing, the cap on the compensatory award for unfair dismissal claims, and changes to tribunal practice and procedure. We'll also briefly revisit the Addleshaw and Woolworths decision that we featured on our last programme. You may remember that we were still waiting for the judgment on this when we reported. Well, that's now been published, so we'll take a quick look at the implications for employers. So first up today then, some key changes to whistleblowing legislation. This is a real hot topic at the moment, both globally with Edward Snowden and at home with revelations about the NHS, CQC and the police conduct of the Stephen Lawrence investigation. So what protection is available to whistleblowers in the UK? Well, as many of you will know, workers who wish to bring a whistleblowing complaint must make what's called a protected disclosure under the Public Interest Disclosure Act 1998, or PIDA for short. This must contain information which, in the reasonable belief of the worker, tends to show one of 6 events has happened. And these include things like breach of a legal obligation or breach of health and safety, or perhaps details of a criminal offence. Previously, protected disclosures had to be made in good faith. However, since the 25th of June, this is now no longer the case, although tribunals will be able to reduce compensation by up to 25% where disclosures weren't in good faith. Although this seems unhelpful for employers, instead, disclosures will only be protected now if workers reasonably believe them to be in the public interest. This change attempts to close a loophole which had previously allowed employees to blow the whistle about breaches of their own employment contracts. However, what about employees who reasonably believe that something's in the public interest, even if it isn't? There's no definition of in the public interest in the legislation, so it seems that everything's going to ride on the court's interpretation of this phrase. Finally, and perhaps most significantly for employers, since the 25th of June, employers will now assume vicarious liability for any detrimental treatment of whistleblowers by co-workers or employees. Basically, this means that employers will be automatically responsible for any detrimental treatment suffered by someone who's made a protected disclosure or who intends to, if that comes from the hands of other employees or workers, unless employers can show they took all reasonable steps to stop any detrimental treatment from happening. Overall, these changes are designed to bring back the real meaning of the relevant legislation, which is, after all, the Public Interest Disclosure Act. However, whether these changes will actually achieve that result is yet to be seen. The government's also confirmed it intends to issue a call for evidence on PIDA in September, so it seems they may not be finished with changing this area of law quite yet. So, some pretty big changes there to consider. I asked Jamie Hamlet, a partner in our employment team, for his views on these changes.
A couple of interesting points which arise there. I mean, firstly, the test of whether or not the disclosure's been made in good faith has gone. And on the one hand, for employers, that might look like bad news because those of us who work in this area have always used that as one of the first lines of attack in trying to defeat these sorts of claims. The second sort of key area of change is onto this focus of a disclosure being made about something which is in the public interest, in the reasonable belief of the employee in question. And one might see a sort of a slightly different approach depending on the sectors. Over the course of the last couple of months, we've seen a different approach taken in a couple of different sectors. And one of the key ones which comes to mind for me is in the health sector, where hospital trusts, foundation trusts, have found themselves under public scrutiny for having outgoing employees sign up to compromise agreements. So the press has made a big deal about people signing, gagging clauses. And of course, all they are confidentiality provisions that you'd find in any standard compromise agreement. But put it into this context, common sense says that it might be easier for somebody who works in that type of sector to be able to make out a case that the disclosure that they make is in the public interest. And I think the other point that I would make in relation to this is actually when you think about this qualifying element of it only needing to be in the reasonable belief of the employee in question, actually has the law shifted massively? Probably in terms of the black letter law, it probably hasn't. What I would say is, and what I hope is, that it will indicate a change in the approach of the tribunal system in handling these claims. Clearly, it's important that the legislation is there and protects whistleblowers where they make these sorts of disclosures, and they do so, and I use the term loosely, but in good faith, about matters which are actually in the public interest. It's important that they are afforded the protection, but we've all seen cynical attempts, as practitioners, we've all seen cynical attempts to say X amounts to a protected disclosure when actually it doesn't. And it's simply done as a tactic to try and lift the cap off unfair dismissal damages. So it'd be really interesting to see what the tribunal do with this when they handle the first cases under the new law.
Thanks, Jamie. Next up, the cap on the compensatory award for unfair dismissal cases is set to change. At the moment, employees can receive an overall maximum sum of £74,200. However, on the 25th of June, legislation came into force giving the government the power to vary this. So there are now plans afoot to retain that overall maximum, but also provide for an alternative cap of 1 year's gross pay for an individual. Whichever is the lower out of those two caps will apply. So given that the vast majority of employees do earn less than £74,200 per year, this is likely to see an overall reduction in the maximum available compensatory award for most employees. Unfortunately, with the government being a little vague as usual, at the moment we know that the relevant regulations are due to come into force sometime in July. We'll let you know as soon as that is. Once they do kick in, the new cap will only apply to employees whose employment terminates on or after the date that those regulations come into force. Once more, I asked Jamie for his views on this development.
Thanks, Helen. One can see, again, on the face of it, that this looks like quite a sort of swinging change, but actually I'm not sure that it is. Although particularly unrepresented claimants were often perhaps led to believe that they would achieve an award close to the cap on unfair dismissal damages. When you think that cap's at around £74,000, and you think what the average worker in the UK earns, you're probably looking at 5 years' losses. Well, often it's been the case that we've said to clients, work on the basis of a worst case scenario for somebody for whom there's no particular reason why they shouldn't find an alternative job within a reasonable period of time. Think about losses being around 12 to 18 months worth of basic pay and benefits. So hopefully what this will do is help to manage the expectations of claimants, that the tribunal isn't actually a forum where they're going to go and get access to untold riches. And I think that's already borne out in when you look at the average or the median awards which tribunals make, they're around £5,000. So it's not a place where someone's ordinarily going to go and expect realistically to open a treasure trove. So if one thinks about the sort of average award at the moment as it stands in the Employment Tribunal for a straightforward, for normal unfair dismissal case, the average figures, the median figures are around £5,000, so not access to huge riches for the vast majority of claimants. And I think just something else to mention as an aside, but again it's helpful in this context of managing claimants' expectations, is that the Tribunal Service itself, when it's sending out the papers at the moment to claimants, well, to the parties, it's making clear what the average award for unfair dismissal cases has been over the course of the preceding 12 months. So those of us who are handling the claims on a day-to-day basis are certainly trying to find a way to draw to the attention of the claimant or the claimant's representative the fact that the claim is in reality probably not worth huge sums of money, and using that piece of information from the Tribunal Service itself to back that up.
Thanks, Jamie. Now for a quick tour of the remaining changes that came into force on the 25th of June. In terms of practice and procedure, EAT judges will now generally sit alone. Tribunals also have more powers and flexibility to make deposit orders, and the annual date for the increase in various awards has changed from February to April. This will take effect from the 6th of April next year. Also, as we last mentioned back on the channel in February, and following the decision of the European Court of Human Rights in Redfern in the UK, the unfair dismissal qualifying period's now been removed for employees dismissed for their political opinions or affiliations. This brings the UK in line with the rest of Europe. Finally, the government now has the power to legislate to outlaw caste discrimination. We're told this will take place sometime during the next 1 to 2 years, so perhaps expect an update on this one in or around 2015. And finally for today, a quick update on the Usdaw case that we covered on our last programme. Well, the official judgment's now been published and has confirmed, as predicted, that the EAT has indeed ruled that the words "at one establishment" are to be deleted from UK legislation for the purposes of collective redundancies involving 20 or more employees. This means that employers will now need to start collectively consulting once there is a proposal to dismiss as redundant 20 or more employees within 90 days at the same business. And this is regardless of whether those employees are based at one site or over several sites. Inevitably, this is going to make things more tricky for large multi-site employers. So if this applies to you, we'd advise putting measures in place to ensure that you maintain a clear oversight of the overall number of proposed redundancies within your business during any 90-day period. For more information about the decision and its consequences, plus our tips for how to best manage the impact, please see our briefing note for employers, which can be accessed at the bottom of the screen. So that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and see you next time.